any offer of a consent? May we have those conversations, Your Honor?
The state, unfortunately, is not going to be present.
I see, Judge. I see. Okay. So I just need just a moment, like I stated, just to figure out how to get my camera enabled, maybe just 2 to 3 minutes, and then I will be ready, Judge.
Okay. And I have, if you have any influence, I have begged the state to be present at these hearings to possibly help move things along, but I'm just a lowly magistrate court judge.
Understood, Judge. I don't think I'm nearly as important as you, but I will definitely make mention when I'm able to.
Okay. But I'll tell you, Miss Lynn, it's not one of those don't catch me in the street. Don't let me catch you in the street notices. I'm not
Okay.
that violent. But
Okay.
I really love to have the input of the state on these proceedings.
I understand, Judge. I was not aware that they weren't present on these proceedings, and it would be my preference as well.
Yes, ma'am. Okay. For everyone, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court, and I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You receive notice at the address you give of your next court date. Lastly, could I have everyone raise their right hand, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay. Miss Lynn, have you worked out your camera situation?
Can you hear me?
I can hear you.
Okay. I have not, Your Honor. I think what I need to do, because I have a glitch on my mobile device, I have another device and I'm about to access that now. For the convenience of the court, would you not mind, Judge, to do your first matter and then circle back around to me? I should be able to access this device momentarily.
Yes, ma'am. Let's start on the ladies' side with Miss Cofield.
Thank you, Judge.
Ms. Cofield, ma'am, you're charged with 2 driving related offenses. The first is speeding. Bond is going to be set at $500. The next charge is driving vehicle without a valid license. Bond is going to be set at $1,000. Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Davis.
Hello.
Ms. Davis, ma'am, you charged 1 count of battery. I'm going to set the bond at $5,000. There's going to be a stay away provision on this bond, to stay away from a Shannon Hibbert. Do you understand that, ma'am? Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Oh,
Ms. Diggs? Ms. Diggs, ma'am, you're charged with 1 count of criminal trespass. Bond's going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Thomas Dwayne Hodges. Do you understand that?
Yes.
You said yes?
Mhm.
Okay. Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? It appears you said NA. Does that mean you're currently not working?
Yeah.
Okay. I'm gonna find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, ma'am, you're free to go back. Miss Hall. Miss Hall, ma'am, you've been charged with one count of giving a false name, address, or date of birth. This is a misdemeanor offense. I'm gonna set a bond at $1,000. You're gonna have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir.
Okay, ma'am, you're free to go back. Miss Shield, Miss Shield, you've been charged with one count of hit and run, leaving the scene of an accident. Bond's going to be set at $1,500. This is a misdemeanor offense. You're going to have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of lawyer?
Yes.
It says here that you earn $12,000 per month.
Mhm.
Okay, you're beyond the threshold of being what we would consider indigent. So your options are going to be to hire your own lawyer, represent yourself.
No problem.
I'm sorry.
There's no problem.
Okay. I'm going to place that you're going to hire your own lawyer. Okay. All right, ma'am. You're free to go back. Miss Silva.
Hi.
Ma'am, you've been charged with one count of hijacking a motor vehicle. And this charge is a charge that I cannot set bond for.
Oh, can I say something,
I'll finish.
Your Honor?
Let him finish.
Hold on, ma'am. I'm gonna give you the opportunity to tell me whatever you want to tell me, okay? So pursuant to Georgia statute 17-6-1, I cannot set bond on hijacking of a motor vehicle. I've set bond on the public transportation, basically not paying for being on public transportation at $500. I've set the bond for criminal trespass as $1,000. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. I'm also setting a bond hearing date for July 8th at 8:30 in the morning, courtroom 201.
Excuse me.
Hold on, ma'am. I'm going to get to you. I promise. Do you want me to appoint you a lawyer? You're going to hire your own lawyer.
I don't care.
Okay. Is that a no?
No,
It's not a no.
whatever. I don't care. Do what you want. You guys just spent 21 hours in the infirmary with one meal and one cup of water. So obviously you guys can do whatever you.
Okay, ma'am. So I'm going to mark on the sheet that you're going pro se because you said you don't care when I was trying to offer you a lawyer.
What does that mean, pro se?
That means you represent yourself.
Yeah, that's
I'm
fine.
out, ma'am. I was trying to offer you a lawyer, ma'am.
So,
I am extremely agitated with the.
You can unmute her. Ma'am, the allegation is that you got on the bus and you got into the driver's seat and you started pressing buttons to try to put the bus in gear.
No, I pressed. the brake.
Ma'am, that's the allegation.
All I did, sir, Your Honor, was press the brake pedal for 5 seconds just to have some fun. I like the noise it made. Then I got down and got out, and he said I'm pressing charges. That's all I did. If you can go to jail and spend 21 hours in the infirmary because of what I did, then you guys need to go to court. I'm taking you guys to court.
Okay, ma'am, let me ask you a question, and you do not have to answer this question. What made you think that you could get into the driver's seat and start pressing buttons?
The both doors were open and it was on. And there was no one around. And I thought, okay, no one's around, so this won't matter if I just play around with the buttons. Because I used to do this to my dad's RV all the time.
Okay, ma'am. Now you see it matters. Now do you see it matters?
What crime have I committed? It's not hijacking if you don't take it anywhere.
Hijacking of a motor vehicle. That is the crime.
Hijacking is.
I know you don't believe that was the crime, but that is the crime.
I'm just saying, hijacking, if you take it somewhere, if you bring it somewhere, take.
Your Honor, are you finished with Ms. Silva?
One last thing.
So you can't say, Barn, I'm going to be here until July. You're saying I'm
No.
going to be here until July.
Ma'am, ma'am, I don't know if you a voter, ma'am, but this law was set by the legislature.
Yes, I am.
I cannot go behind the law. I am a person that is responsible for making sure that the law is followed. And I'm sorry that your attempt to have fun is going to have these collateral consequences.
Are you saying I'm going to be here until July?
Yes, ma'am.
Let me just tell you something. Hijacking, looking up on Google, hijacking is when you take it somewhere off the premises or you move it at all. I didn't touch it. I did not hijack anything. There was nothing to jack. There was nothing to hijack. Okay, sir. I plead this case, and Your Honor, please see that I was merely just.
So I'm gonna go back to the threshold question. Do you want me to appoint you a lawyer?
What will that do?
Are you gonna hire a lawyer?
What would that do? Because no matter, because I'm speaking in English here, and you're not understanding.
Yeah, I do. You're answering a question with the question. So I've marked pro se, which means you're going to represent yourself until you hire your own lawyer.
I don't need a lawyer.
You're now free to go back. She's free to go back.
Can I get our OGR bond or whatever? Can I get a bond? You're saying I'm to be here until July.
Miss Lynn,
Yes,
you got your camera to work.
I did, Your Honor. Thank you for your patience.
Yes, I'm down to the last person on the lady side, and then we'll move to Mr. Smith.
Yes, sir.
Wendy Ward. Lady side, I think it's Ward, and I think it may be Spink, or there's Spike or Spink, or there's another name.
This is Ms. Ward, Your Honor.
Yeah.
Okay, Miss Ward, ma'am, you're charged with 1 count of violation Georgia Controlled Substance Act, simple possession of methamphetamine, setting a $3,000 bond. That's a felony offense. You're charged with 1 count of possession of marijuana less than an ounce. That's a misdemeanor. Bonds can be set at $1,500. You're also charged with 1 count of use or possession of drug-related objects. Bonds going to be set at $1,500. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. Most likely will be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
What is the total of the whole amount?
$6,000, but there are going to be fees that the sheriff's department is required to add by law. So it'll be a little bit higher than the $6,000 figure.
What is the percentage on like a bondsman with that?
Okay, it's in I'll preface my statement with saying that I don't work for the bonding companies, but their fees are based on a percentage anywhere from 10 to 12% of the bond amount.
Okay.
So I think there are 5 or 6 bonding companies that are authorized to write bonds here in Clayton County. I would encourage you to contact each one. Okay?
Have a great day.
You too, ma'am. You're free to go back.
Thank you.
All right, let's bring up Mr. Bernard Smith.
I've got to wake up. So I'm next. Yes. You're next. He's got his attorney here, so he's going first. Right here. Okay. No, Bernard.
How you doing?
Are you Mr. Bernard Smith?
Yes, I am.
Mr. Smith, ordinarily I would speak to you directly. You've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to your lawyer about your case. You should understand that anything that you say here is not privileged, nor is it private. So please don't say anything that you would not want the whole world to know. You understand me, sir? Okay. Attorney Lynn. Mr. Smith is charged with 1 count of public indecency. This is a misdemeanor offense. I've set a bond at $1,000. I would listen to you as to anything you want to say about your client as to the charge or to his or about his characters. Word that comes to mind, but it's not character, but about your client. You still muted.
Can I be heard now, Your Honor?
Yes, ma'am.
Okay, thank you, Your Honor. Judge, for your own edification, just so you know, Mr. Smith's background, he is currently 43 years old. He is a United States military Navy veteran. He served this country for 4 years in the Navy. He, within that, judge, suffers from mental health diagnoses that I would not like to say on the record at this time, but
That's fine.
Thank you, Your Honor. I appreciate that. But there are diagnoses, Judge. On the previous dates surrounding this particular day, which was May 26th of 2022, prior to those dates, Mr. Smith had made some attempt to go to the hospital to receive medical treatment for his condition. He was not able to reach the hospital on that previous occasion, which was May 23rd of 2022, because he had been in a motor vehicle accident. And so it's my belief that there may have been some lag between May 23rd and May 26th of him being able to receive the proper medical care that he needed. On the day in question, it's my understanding that there may have been some disagreement with a neighbor where he lives. From there, he apparently was hospitalized twice on May 26th. At some point, he was released. He went through whatever protocol those facilities had. He was released, and he was subsequently, I'm not sure if he was medicated there, if he wasn't medicated, what exactly occurred. But he was later found walking down Terra Boulevard in his hospital gown. From that point, he was sent to another facility, which I believe was Piedmont Hospital. In between that time, I believe warrants were drawn up for the public indecency charge. And so he was treated, released from Piedmont, and then rearrested on these warrants as of late. So, Judge, I would like to ask, given the circumstance and my belief that this is not a criminal matter, but more so a mental health matter, if Your Honor would allow Mr. Smith to sign himself out. Of course, as you know, Judge, he's entitled to a bond on a misdemeanor. But we're asking that you allow for him to sign himself out on his own recognizance to deal with the mental health matter. And we ultimately want to see if we can have this case done away with altogether.
Okay, so I set the bond at $1,000, which is my understanding lowest amount that a bonding company will entertain a bond or will come on to a bond. I'm not inclined to allow him to sign himself out by and large, because we really don't have infrastructure in place to monitor a person that gets a signature bond. So I understand what you've said, and with the bond amount that's set, he should be able to pay between $100 and $200, and I don't know what bonding company or whatever he's going to go through as it relates to that. But there is there's case law about if someone has been diagnosed and they're told to go through a certain treatment or regimen of treatment, and they don't comply with that's treated as voluntary intoxication. And so, and I'm certain, like you can't drink a whole bottle of alcohol, get in your car, drive and kill somebody and say, well, I was drunk and that's why it happened. So those are issues that are going to have to get fleshed out as it moves along the path and the chain. But if your client is in a situation where he's been told to take medication or to on a certain regimen and he's not doing that, that's something that may not be a benefit to him.
Understood, Judge. I would like to have more probing discussion with Mr. Smith. I don't believe that is the case in this instance. I do believe that he is in making all the attempts that he can within his power to receive the care that he needs, but I most certainly will take what the court is saying into consideration and have some more probing discussion with him on that matter.
And that's, and I'm this is not a situation where I would be inclined to dismiss the warrant. And I know that's not what you're asking. But I set the bond at an amount. As I said, it's the lowest amount that from my understanding, that a bonding company would entertain this, so that from a financial standpoint, he comes out better. If I set a $500 bond, he's going to have to pay $500. But setting the $1,000 bond, he can go through a bonding company and have a lower outlay as it relates from the beginning.
Yes, Judge. And I do certainly appreciate your consideration. And I do believe that that is correct. That's my understanding of the bonding process as well.
Okay. So Mr. Smith can go back and Miss Lynn, you can be excused.
Thank you very much, Judge. And I appreciate you not penalizing me despite Miss Mary's suggestion.
But she holds me in contempt every day. So
Oh, I know all about it, Your Honor. Trust me.
okay, have a good day.
Thank you, Judge. Have a great day as well.
You
Talk to
too.
you soon, Mr. Smith.
Let's bring up Mr. Bullock. Mr. Bullock, sir, do you know what you're charged with?
Yeah.
I cannot set bond on this offense at this stage. So bond is going to be denied on the first count, CW 52785. It's going to be denied pursuant to Georgia statute 17-6-1. And the second count, CW 52786 is going to be denied because the first count I can't set a bond, and I'm going to let the next judge set the bond amount. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working, sir?
No.
Okay. So I'm gonna appoint a lawyer to represent you. And your bond date is going to be set for July 8th at 8:30 in the morning. Do you have any questions for me, sir?
No.
Okay, sir, you're free to go back.
All right.
Oh, man. Are you Mr. Burdette?
I am.
Sir, you charged one count of simple battery. This is a misdemeanor offense. I'm setting the bond at $4,000. There's going to be a stay away provision on the bond to stay away from a Keith Burdette. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir?
Yes.
I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, I have a bench warrant hold. My attorney on that bench warrant set the date on the case for July or June the 27th, I think it was, or the 21st. And now I have a bench warrant out on my arrest for failing to appear. I did not fail to appear because the court case was not had not come about yet. I have a hold on a bench warrant, and I shouldn't have a bench warrant. That my attorney, my public defender, on a Zoom call that day set the court case back for a mental evaluation. I have not received that paperwork or the mental evaluation on that court case yet. I don't know where I'm supposed to go, who the attorney was. I can't remember the lady's name.
What county?
Clayton, City of Morrow also.
City. Okay, so was it a charge out of City of Morrow? Or was it a state charge, meaning It's
It was a charge at City of Morrow, but it was Clayton County courtroom.
okay. So, because of the whole pandemic thing, there are ways to kind of work around it. But it just requires communication. And I'm not saying that your side has not been trying to communicate with the state side, but it requires both sides to be able to communicate and resolve whatever issue is ongoing. So I would, well, I'll say this. If you were to post bond in this case, it now places your other issue at the front of the pile. And then that issue most likely will get resolved possibly faster. If your lawyer has not been able to resolve that matter, once you get placed upon the City of Morrow and they have to deal with you, then they may actually deal with you. But as long as you're kind of in the pile and paperwork, you may not get the attention that you deserve.
Okay, so what I'm asking is, if I bond out on this charge, I have to sit here until the court date on the bench warrant, is what I'm asking. I want a fake bench warrant, where my attorney had reset the date to July or June the 27th, I believe it was, or the 21st.
Yes, that is the procedure. But what I'm saying to you is that once you are now placed before them and they have to deal with you, they will deal with you. If your attorney has been unsuccessful up until this point in dealing with the issue, once they have to come and place you on a calendar and deal with you, that will help the matter to get resolved. And it may lead, and this is by way of observation from 22 years of practicing law. The prosecutor in Morrow that may have ignored this, once the prosecutor know they have to deal with it, they will deal with it. It's the whole thing of, like they say, well, I won't say that, but I'll say this. Once your issue is front and forward in front of them and they can't shirk it, they got to say yes or no. And if it's a failure to appear and it's a situation where there are reasons for the failure to appear, almost every jurisdiction say, let's just put them on the calendar, especially when you have a lawyer. They say, let's put them back on the calendar and we'll deal with it. So I don't know the details of your situation, but you have a lawyer, and I would encourage you to just listen to what the lawyer's saying.
That's the problem. You can't get in touch with the lawyer, but that's fine. I'm gonna say this on the camera. You need to get in touch, or Clayton County needs to get in touch with General Adam Hutchinson, United States Army, on a satellite terror attack in Clayton County in the City of Morrow that I've been under for the last 7 years. That's what this is about. The Johnsons, the Monroes of the state of Georgia. So I want that on camera. I thank you, Judge. I'll let you.
You're welcome. Thank you, sir. Mr. Cannon. Good morning, Mr. Cannon. Sir, you're charged with one count of firearms solicitation to transfer, and the allegation is that they're 9 firearms that didn't belong to you that you were attempting to sell to a pawn shop. Bond is going to be, that's a felony offense. Bond is going to be set at $10,000. You're also charged with cruelty to animals, and bond is going to be set at $10,000 because I saw that there was another incident or allegation of cruelty to animals. So you're going to have a total bond set at $20,000. Because these are both felony offenses, you're going to have a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. When I was actually going through intake and booking, when I was actually speaking to the officers during the arrest, they said the cruelty to the animal was an actual misdemeanor charge. My dog, they said my dog was going through a heat situation when she
heat
actually,
stroke. Right, heat stroke.
when she actually got taken into Humane Society, it was determined that she has parvo.
Okay.
Now, I bought my dog. Yes, go ahead, sir. I'm sorry. I didn't mean to.
No, I was going to say that that's a circumstance that you need to speak to your lawyer about.
Yes, sir.
Because that will kind of carry the day, but right now it's being written as a felony.
Yes, sir. Understood.
Okay. All right. You're free to go back, Mr. Cannon. Mr. Cozen.
Yes, sir.
Is it Cozen or Cozine?
Cozine.
Cozine. Mr. Cozine, sir, you charged with 1 count of simple assault. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond, a stay away from a Lauren Webster. Do you understand that, sir?
I do.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you make per hour?
$17.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Hanfield.
Good afternoon, Your Honor.
Good afternoon.
I'm sorry.
I'm sorry, Miss Mary.
I said, what was Cozine's bottom amount?
$3,000.
Thank
I hope you're having a good day, Your Honor.
Well, I hope I have a good day too, sir. You're charged with 1 count of aggravated assault by strangulation. I've set the bond at $15,000. There's going to be a stay away provision on the bond, stay away from a Charlene Hanfield. Do you understand that?
Yeah, Your Honor, my wife and I have been going to marriage counseling since the incident in January. We actually attend the VA. I'm a veteran. We attend marriage counseling through the VA. Yeah, I have my two babies, my 2 children at the house. That's the only residence that I have, Your Honor.
Okay. All right. I'm gonna reduce your bond to $10,000.
Thank you so much, Your Honor.
You're welcome. There is going to be a stay away provision on the bond, stay away from Charlene Hanfield. And I know you said that you've gone through counseling, but we place stay away provisions on these bonds for a reason. If she would like to have this condition modified, she can contact the district attorney's office.
Is there a number you can give me to call, please, Your Honor?
It's the Clayton County District Attorney's Office.
Clayton County District Attorney.
Yes, sir.
Your Honor, is there somebody in reference that she should speak to, or just ask for the district attorney?
Victim witness advocate. But she should be the person making the call.
Yes, Your Honor. Yes, totally understandable. I'll relay. I'll have the message relayed to her. I won't even contact her to let her know.
Do you want me to see if you qualify for the appointment of a lawyer?
Please, Your Honor.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
About the bond, Your Honor. I just need to have some. I can't post that myself. I have to have somebody else post it.
Okay.
No, I was asking you, am I allowed to post? If I post it, I have to pay 10,000, right? But if I get a bill company, I can.
You can go through a bonding company. It's what we call cash, commercial, or property. Cash, you can post the entire amount of cash and you'll get that returned to you when the case is over. Commercial, you go through a bonding company, they charge you a fee, but whatever fee that they charge, you don't get that money back. Or property, if you have property in Clayton County that is, it has at least 3 times equity of the bond amount, you can post that property. And they'll put, the sheriff's department will place a lien on the property. And when the case is resolved, they will remove the lien.
Understood, Your Honor.
Okay, any other questions?
Preliminary hearing, Your Honor?
Is July 6th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail.
Yes, Your Honor. Thank you, Your Honor. You have a good day. God
You
bless.
too. Mr. Hodges.
Yes, sir.
Mr. Hodges, sir, you've been charged with a number of serious felony offenses. The armed robbery charge, I cannot set bond at this stage pursuant to Georgia Statute 17-6-1. So with aggravated assault, I'm denying bond on that charge. The armed robbery bond is denied pursuant to Georgia Statute 17-6-1. Criminal damage to property in second degree, which is also a felony, I'm denying bond on that charge. With criminal trespass, that's a $3,000 bond. Battery is $5,000 bond. And misdemeanor theft by taking, there's a $2,000 bond. There's going to be a stay away provision on this bond to stay away from a Tamara Diggs. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. Courtroom 201. The armed robbery is going to have to be heard before a superior court judge, and that date will have to be provided to you later, because armed robbery carries maximum sentence of life.
All right.
So I cannot give you a hearing date for that today. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Hodges. Mr. Jones?
Good afternoon, Your Honor.
Good afternoon, Mr. Jones. Sir, you're charged with one count of theft by taking as a misdemeanor. Bond is set by schedule at $2,000. There's going to be a preliminary hearing date that's going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I'm sorry, wait a minute. Yes, sorry. Put the wrong date down on the paperwork. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor, please.
Okay, I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So so my bond set at 2,000. I can go to a bond company and get that taken care of.
Yes, sir.
And for my actual offense, what I'm being charged with, like, so somebody,
Hold on. Don't talk about the facts of your case.
I just wanted to know about the belongings, because I was told about these belongings that was taken, that they wasn't really taken. Like, I still have the stuff. I asked this person to come pick her stuff up, and she told me she was calling.
Mr. Jones, you're talking about the facts of your case.
Yeah.
And let me tell you why I stop people from doing that. This is being recorded.
Yeah. Yes, sir.
You have not spoken to a lawyer yet about any possible defenses that you may have. So how about wait until you speak to a lawyer?
First, okay. Thank you, Your Honor.
Yes, sir.
I'm finished.
Yes, sir.
All right, you have a good day.
You too. So Larkins.
Real Larkins. Real Larkins. Mooney.
Good morning. Are you Mr. Larkins?
No, Mooney.
I'm sorry?
Mooney, gentlemen.
Mooney, Mr. Mooney, sir, you charged with one count of violation of Georgia Controlled Substance Act, simple possession of methamphetamine. Bond is going to be set at $3,000. You're charged with improper lane change. Bond is going to be set at $500. Charged with use or possession of drug-related object. That's also a misdemeanor. Bond is going to be set at $1,500. And you're charged with driving on a suspended license. Bond is going to be set at $1,500. That's a total bond of $6,500. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you make per hour, Mr. Mooney?
Maybe $9 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, not at this time.
Okay, you're free to go back.
Thank you.
You're welcome. Did we lose Mr. Larkins? Mr.
Palominos.
Palominos.
Yes, hello, Your Honor.
How are you doing, sir?
Good, sir. How you doing?
I'm doing well. You're charged with 1 count of trafficking marijuana. And in the state of Georgia, anything over 10 pounds, I cannot set bond at this hearing. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. You're going to have a bond hearing date set for July 8th at 8:30 in the morning. I would encourage you to hire a lawyer
Yes, sir.
because the lawyer may be able to negotiate with the district attorney's office and have you released before these dates
Yes,
that
Your Honor.
I have laid out. So is it your intent to hire your own lawyer, or do you want me to appoint you a lawyer?
If you can appoint one, that'd be highly appreciated.
Okay, you do qualify. I'm going to appoint you a lawyer. Do you have any questions of me?
Yes, sir. As far as the lawyer goes, the attorney, how would he be reaching out to me, or how's that going about in the state of Georgia?
So, my basic answer to that question is always, I don't work for the district attorney's office. I'm sorry, the public defender's office. So I cannot tell you when, but I do know that for the clients that they are appointed, they reach out to them as soon as possible on the video terminals. They set up meetings.
Yes, sir.
And the way it goes here, at least in Clayton County, at the end of this hearing process, I complete the paperwork and I send everything back to the public defender's office as it, Jesus, I'm getting these names wrong. I send everything back to the sheriff's office as it relates to the bond orders. There's an indigent defense office that I send the paperwork over as to the people who are requesting a lawyer. They process it and then they send it over to either the misdemeanor or the felony divisions. So
Gotcha.
that's the process of appointment. So I can't guarantee you like a timetable. From what I have observed, you'll get contacted this week, and you can tell them what you need to tell them. And I'll tell you,
Yes,
because these cases come to Clayton County, you're not the only person.
yes, sir.
And coming from out west, and these cases happen on a frequent basis. So if you have the ability to hire a lawyer, it may help speed the process along.
I definitely can. It's just a lot harder being, incarcerated due to the fact that I am in Georgia and whatnot. I know if I had that ability, I would be a lot more able to do,
Right.
the right lawyer for me. So,
Right. And so I would just,
I definitely could definitely use a lawyer, how you're saying. It'd be a lot more doable for my feet and my hands to be, out on the will to do that and to appoint the correct lawyer.
well, these are felony offenses, and I'll tell you, the judges, we're all on rotation. And when I come over into the preliminary hearing realm, the lawyers from the public defender's office do a great job in representing their clients because I'll call it muscle memory, because they're dealing with the same people and they know what's going to happen, how it's going to happen. They know where to push, where not to push. And so I've seen them be more effective, honestly, than
Gotcha.
some of the retained lawyers.
Okay, all right. Oh,
Okay.
yes, sir.
All right, sir. You're free to go back.
Thank you. Have a good day.
You too. Mr. Reed. Mr. Reed, do you understand what you're charged with, sir?
Yes, sir.
I cannot set bond for this offense at this stage. So bond is going to be denied pursuant to Georgia statute 17-6-1. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. Courtroom 201, but most likely it'll be by Zoom. You're going to have a, well, for the second charge, bond is going to be denied, just because I'm going to let the judge that handles the bond deal with both charges. You're going to have a bond hearing date set for July 8th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
So, okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I'd like to state this for the record. Deputy do the interview, he coerced me. I was under influence.
Okay. That you should tell your lawyer that. Is there anything else, Mr. Reed?
Yeah, everything that they written down, that was coerced. I was under influence, sir.
Okay. So the way that gets handled, Mr. Reed, is your lawyer, once the case is indicted, files a motion to suppress statements, and then they go through that process. The court analytical process of determining whether a statement was coerced or not. Is there anything else, sir?
That's it.
Okay, sir. You're free to go back.
Yes, sir. Thank you, sir.
You're welcome. Mr. Richards.
Good morning, Your Honor.
Good morning, Mr. Richards. Sir, you're charged with 1 count of battery.
Keep it down.
Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from Joshua
Yes, sir.
Richards. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. That'd be awesome.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. I don't.
Okay, you're free to go back.
All right. Thank you.
You're welcome. Mr. Russell.
Good afternoon.
Good afternoon, sir. Mr. Russell, you're charged with 1 count of violation of Georgia Controlled Substance Act. And bond is going to be denied pursuant to statute 17-6-1. There's an allegation of 13 pounds of marijuana being trafficked, and I can't set a bond for anything over 10 pounds. You're going to have a $5,000 bond set on possession of a Schedule II drug. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for July 8th at 8:30 in the morning, courtroom 201. But most likely both of those hearings will be done by Zoom. Do you want me to see if you qualify for the appointment of lawyer?
Sir.
You said yes.
Yes, sir. Yes, Your Honor.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, Your Honor. I was under the, you said I got a trafficking charge, correct?
Yes, sir.
Yeah, I was under the assumption that I got hit with possession. Did not within the state. I never was flying or anything like that. I was in the state. So the officer informed me that I was hit with a possession charge versus trafficking because I didn't cross any state lines.
Okay. So it says that you were on a Delta flight.
Sir, I never was on the flight, sir, and the officers know that. I never was on the flight. I just was in possession of the luggage at the airport. And they told me that I had possession, and that was it. That's what we talked about when I was with the officers yesterday. So there's traffic, and I'm kind of confused on because I didn't cross any state lines.
So state lines only apply to a federal charge. They call it interstate commerce.
Yes, sir.
If you're in possession of more than 10 pounds of marijuana under Georgia law, that's considered trafficking. So if it's 9 pounds, I can set a bond. 10 pounds and 1 ounce, I can't set a bond.
Yes, sir. Understood.
Okay. Okay. Do you plan to hire your own lawyer? You want me to see if you qualify for the appointment of a lawyer?
Yes, sir. I think you just told me that I do qualify.
I did. Okay. Any other questions?
No, sir.
Okay, Mr. Russell, you're
Oh,
free
I
to
do
go.
have my
Yes, sir. Yes, sir.
With the court-appointed lawyer, I won't speak to them until, is there a way that I could possibly get a bond before the next hearing, or have to wait until that hearing to receive a bond?
So, yes, the short answer is yes, you can get a bond, but it'll have to be a consent bond through the district attorney's office.
And the only way to do that is by hiring my own lawyer, correct?
Well, the potentially the fastest way to do it is to hire your own lawyer. But the lawyers that are in the public defender's office, at least the ones that I interact with on preliminary hearings, are very good lawyers.
Yes, sir.
But they have volume.
Correct.
So it's a decision that you have to make.
Yes, sir. Could you give me a realistic timetable dealing with the public defenders?
I don't have the number,
Yes, sir.
but it
On
is
that bond date, though, that would be, I guess, the timetable, correct?
the bond hearing date is July 8th. I'm sorry. Yes, July 8th at 8:30 in the morning. So the thing that I think you should have to understand is that to the extent this is a nonviolent offense, and to the extent that you're not, El Chapo, the district attorney's office will work with your lawyer in determining what they believe to be a reasonable bond. It may not be a bond you believe reasonable, but they will most likely offer a bond, and it'll be a decision that you have to make.
Yes, sir. Do you have an idea of what that amount could be for that charge? The minimum, at least, could you tell me that?
I'll say, and it all depends on criminal history, circumstances. I think the lowest that I've seen agreed to is about 25,000. The highest that I've seen is 75,000.
Sir, I just wanted to know.
Yeah. Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Smith. Mr. Smith, sir, you're charged with 2 misdemeanor offenses. Theft by shoplifting as a misdemeanor, bond is going to be set by schedule at $2,000. Possession of marijuana less than an ounce, bond is going to be set by schedule at $1,500. You're going to have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. The form I have, you did not fill out. Are you currently working?
No, sir.
All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't think so.
Okay. You are free to go back, sir. Mr. Willis, sir, you're charged with 1 count of felony theft by taking of a motor vehicle. Bond's going to be set at $15,000. There's going to be a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own?
Yes, sir.
All right. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back, Mr. Willis.
Thanks so much.
You're welcome. All right, do we have Mr. Larkins?
How you doing, sir?
I'm doing well. Mr. Larkins, sir, you're charged with 1 count of aggravated assault by strangulation. Bond is going to be denied on that charge.
No.
Sir, let me finish. You're charged with 1 count of terroristic threats or acts. That's also a felony offense. Bond is going to be denied. You're charged with 1 count of simple battery. Bond is going to be set at $3,000. 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a delinea day. Do you understand that, sir?
What I don't understand is, I've been in that house.
Mr. Larkins, I'm gonna let you speak.
All right.
I'm gonna shut my trap and I'm gonna let you speak. But I gotta tell you certain things, okay, sir? Do you understand that there's gonna be a stay away provision to stay away from a delinea day?
Yeah.
Your preliminary hearing date is gonna be set for July 6th at 8:30 in the morning. Your bond hearing date is going to be set for July 8th at 8:30 in the morning. Do you plan to hire your own attorney, or do you want me to appoint you an attorney?
I need help with that. Public defender, I guess.
Okay, I'm going to appoint you an attorney. And just so you know, Mr. Larkins, I'm going to listen to everything you have to say, but I also have to do my job and give you information. Okay, so I've done that part. Now I'm going to shut my mouth and I'm going to listen to you.
How is that terrorist? I don't understand the trespassing. I've been living in that house with that same woman. We've been together for 14 years. I've been there for 9 years in that same house.
Okay. Oh, stop.
Moved in this
And no, and the reason I say stop is because people will rattle off 10 questions. And I'm like, just ask one question, I'll answer it. Ask a second question, I'll answer it. Okay.
Yes.
So in the state of Georgia, criminal trespass can be accomplished in 2 ways. One, you're at a place or location that you've been told to stay away from, or you damage the property of another without their permission. And it can be joint property. So it doesn't have to be a situation where Miss Day owns the property completely. If you and Miss Day own the property jointly and you destroy the property, you've destroyed her interest in the property. So that's where criminal trespass, and in this case, is saying that there is a TV that was broken. Okay, so that's the allegation. As you stand here now, you are an innocent person.
No, I said it was my TV. I broke it.
Okay. Okay. What's the next question, Mr. Lark?
And then the call was made from someone else over a phone call that wasn't even in our household. I don't understand that neither.
You said the what?
The call was made from someone else that wasn't in our household.
To call the police?
Yeah. Even me and her both was looking like, what were they there for?
It doesn't, the call does not have to come from a person within the household. So say for example, you see a car in your neighborhood and you think,
how could they say strangulation then if she didn't say it?
Mr. Larkins, you've jumped to the next question.
I'm sorry.
I promise you, sir, take a breath. I'm going to answer every question that you have. Okay? Say, for instance, there's a car in the neighborhood that you don't recognize, and you call the police about that car, and then they stop that car, and it turns out there's ski masks, handguns, and stuff from other robberies. The people in the car can't say, well, who called the police? We haven't done anything. People can call the police about suspicious conduct, and the police are entitled to conduct their own investigation. Doesn't mean that you're going to be found guilty. But that's how this stuff kicks off. So what was your third question?
I just don't understand how they can say strangulation. And she ain't saying that. But
Hold on. If you want me to read it to you, I'll read it to you. So it says that you placed your hands around Miss Day's throat and began choking her while stating you would kill her.
That came from someone. That came from someone else making a phone call.
Well, it appears that the allegation from the affidavit is that the sister, Mr. Larkins. Okay, remember the ground rules?
Sorry.
Thank you. The sister apparently was on the phone and called the police when she heard something going on in the background. So the only person that could provide the information to the police is Miss Day. Did they separate the two of you?
Yeah.
So you don't know what was said while you were separated. So now you know what was said.
Her sister said that.
Mr. Larkin, I'm going to try this once again. You and Miss Day were separated when the police came, correct?
Right.
And she was speaking to the police, correct?
Right.
Your sister, her sister was not there, correct?
Right.
So who's the only person that could say that?
It's Miss Day.
There you go.
Because she the one told me that her sister told it.
Mr. Larkins, you can continue believing that.
Oh, shit.
And I'll continue believing in the Easter Bunny. How about that?
Damn, I believe you. Oh, but thank you, Your Honor. Oh, shit.
Anything else, Mr. Larkins?
No, thank you. So you said July 6th and July 8th?
Yes, sir.
Thank
Okay, free to go back.
you.
Is there anybody else you need to see, Your Honor?
No, sir. Not unless you're gonna try to force them on me. I'm gonna start calling you Detective Raquina. since I had that misstep. Have a good day. I will see you all tomorrow.
Yes, you have a good day as well.
Okay.